Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is our private Facebook group, and if you're in foreclosure, you're certainly welcome to join us. We help each other with our foreclosures. Today we're going to talk about Rachel Tennyson and her case, and how, what's going on in her case. It's pretty interesting, actually. So let's take a look. If you go to Pacer and you want to look up her case, guys, it's in the Northern District of Texas, the Dallas division of Pacer, and her case number for her main case is 325CV00661. And if you put that number in the query, it'll come up like this: Tennyson versus Loan Care. She's suing them for a quiet title action. And as you can see right here, she filed her complaint March of 2025. And then you can read, basically what's going on here. Basically, they filed a motion to dismiss, and she filed an opposition to their motion to dismiss, which, as you can see right here. And the last thing she filed was her memorandum of law in opposition. And then they filed a reply. And so we're waiting for the judge to rule on that. And then she filed notice regarding related case on 6/24. So this is what's happening, guys. Texas is a non-judicial foreclosure state, which means they can just sell your house and not take you to court. But in this case, the other side is taking her to court, and there's a related case. So if you want to look up the related case, let's see here. This other case in the same court is 325CV01232. And this time it's Lakeview Loan Servicing versus Tennyson. And they filed a complaint, a judicial foreclosure. They filed on 5/14/25. And so what she did was she filed a motion to dismiss on June the 12th. The judge issued an order telling them they have until July 3rd to file a response. Well, as you can see, today's July the 3rd, they have not filed a response. And what is this on June 24th? A notice. Let's take a look at what that looks like. Okay, so she filed a judicial notice in the court, as you can see right here. Judicial notice regarding related cases. And she's giving this to the clerk of the court, and the clerk of the court filed it in the case. Basically, she's telling the court that the other side is forum shopping, and what they're doing is just harassment, actually. If you can see here, there are other cases that they're doing this to people, not just her. She did her homework and her due diligence, and she found these cases, part of a larger pattern by Lakeview and Maranowski law firm, or law group, which is located in Addison, Texas. And they do a lot of judicial foreclosures in that whole area. And these are the cases that have the same exact situation. These are judicial foreclosures in a non-judicial state. And they're trying to use HUD as a way to get federal jurisdiction when there's a problem in the title of all these cases. Otherwise, they would have just sold their house and not even taken to court. But there is a problem with all these. These are HUD. Basically, what they did was they did loan modifications in people that had HUD loans or FHA loans, and they made them do what's called a partial claim in their deed of trust, which makes it so that HUD is actually a party to it. And so if they can take them to federal court and basically do a quiet title action, then they can get rid of HUD so that HUD can't get anything out of the deal. And anyway, so basically she just brought this to the court's attention, letting them know about this forum shopping that Maranowski Law Group is doing. And interestingly enough, she also sent letters to everybody that has similar cases, letting the people know, look, you're just like me. They're doing this to you. They don't have title to your property. They're trying to get title to your property. Otherwise, they would have just sold your house. As you can see, here's a copy of one that was filed in this person's case, 325 CV00106. It's also in Texas. It's also almost the same situation. So she basically let the court know about the forum shopping scheme. Notice a pattern federal forum shopping scheme involving Maranowski Law Group and Sammy Huda. And she's telling the judge, Judge Brown, I respectfully write as a member of the public and pro se litigant who has been independently tracking and researching a pattern of suspicious foreclosure-related litigation in federal courts across Texas. I urge the courts to take judicial notice of a disturbing trend that is directly relevant to the above captioned case. The undersigned has reviewed the public record filings in case, there's the case number, and notes that it appears to follow an emerging pattern. Mortgage servicers, particularly Lakeview Loan Servicing, LLC, has been repeatedly filing federal quiet title actions invoking jurisdiction under 28 U.S.C. 2410. These suits uniformly name the Secretary of Housing and Urban Development, HUD, as a defendant based solely on the existence of a subordinate FHA partial claim lien, despite the lack of any true federal controversy or adversarial claim. In other words, they're making FHA or HUD a defendant. Critically, in the case of Gibson, there is no recorded assignment in the county land records, indicating Lakeview Loan Servicing, LLC, as the legal holder or beneficiary of the deed of trust. Nonetheless, a loan modification was executed despite this lack of recorded authority. This raises serious questions about Lakeview's legal standing and the legitimacy of the foreclosure remedy now sought in federal court. Executing a modification without a perfected assignment reflects a broader pattern in which these servicers seek to retroactively justify enforcement rights they never properly secured. To date, no defendants, including HUD, have been served in these cases. Isn't that amazing? They get these cases, but they don't serve them. No certificates of service appear on the docket, and no summons returns have been filed. This delay in service is consistent with a pattern observed in other cases and appears to serve the purpose of stalling the litigation to maintain federal court jurisdiction without advancing the case on the merits. In short, it is further indication of forum shopping, not genuine foreclosure litigation. And let's see here. Moreover, it is important to highlight that this foreclosure was originally initiated by Maranowski Law Group in Galveston County State Court, December of 2024. However, that case did not proceed likely because no valid assignment to Lakeview Loan Servicing existed at the time, or because the case could not withstand state-level scrutiny of standing and real property and interest requirements. Instead of curing the defect, Maranowski waited and refiled in federal court April 2025, now adding HUD solely to trigger jurisdiction under 28 U.S.C. 2410. This maneuver appears to be nothing more than a calculated attempt to avoid state foreclosure law, state judges, and due process protections. This is not an isolated incident. I repeatedly call the court's attention to a growing list of similar federal actions recently filed across multiple districts in Texas, including, and as you can see, there's a long list here, guys. You see these? These cases all share a net of troubling features. The named plaintiff often has no recorded assignment or perfected lien at the time of suit. The same law firm, Maranowski Law Firm, PC, and attorney Sammy Huda appear across filings. HUD is used as a jurisdictional anchor to improperly invoke federal jurisdiction, despite HUD being a passive lien holder without adversarial interest. In many of these cases, no certificates of service have been filed for weeks or months post-filing, suggesting the cases are used to manufacture jurisdiction while avoiding prosecution on merits. In the Coda case, the United States Attorney's Office for Western District of Texas via U.S. Attorney Darrell S. Vereen conceded in writing, defendant admits the Secretary of Housing and Urban Development is lien holder of record on the property and asserts HUD's right to any proceeds from any sale and our judicial sale of the real property in question in the same priority of its interest. The Department of Justice, the DOJ admission confirms HUD has no adversarial ownership claim or dispute justifying federal jurisdiction. Nonetheless, servicers and their counsel continue to rely on this tactic in what appears to be a coordinated scheme to bypass state foreclosure protections. I respectfully ask this court to take judicial notice of this growing federal forum shopping scheme now being executed on this case and others. Okay, so basically that's pretty much the sum of what she's saying, and she's making all the courts aware of all this, so now all the judges are aware of this is going on. Okay, guys, that's it for today's episode. If you have any questions about foreclosure, or if you need help with yours, or you just want me to look at your stuff, guys, some people send me their stuff and I look at it for them, and that's fine. Just send me an email. My email address is foreclosurehelp777@gmail.com. It's with the number 4. So if you send me an email, I will try to answer your email. Okay, guys, thanks for subscribing to my channel. I hope everyone has a wonderful 4th of July, and God bless.